The prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. Now that, in part, is the American Bar Association's rule of professional conduct for prosecutors, a rule some prosecutors in New York City take as a gentle suggestion, since they don't share any evidence with the defense until the day the trial actually begins.
There is, however, a movement to reform the rules surrounding discovery, the process where prosecutors reveal the evidence they intend to use in court against someone accused of a crime. So what exactly is the law here in New York, and how does a procedural step like discovery affect trial outcomes? To help shed some light on the subject, we're happy to welcome back the Legal Aid Society's attorney in charge of criminal practice, Tina Luongo. Thanks for joining us again.
Thanks for talking about this.
Yeah, it's a big deal, right?
It's a very big deal. You know, you're saying thanks for talking about this, but when I sort of became aware of the situation, I was wondering why everyone isn't talking about this. So can we just walk it back a little bit?
Sure.
What is discovery, and how is it sort of carried out in New York City as we know it today?
Sure. So discovery is the exchange of what people would call the evidence in the case. Police reports, witness reports, video, right? And the way I like to sort of define is sort of to distinguish the differences between civil discovery or disclosure and criminal, in the criminal system, discovery or disclosures to show the real disparity. If you were rear-ended in a car accident and you hired a lawyer and that lawyer launched a case.
Civil matter.
Civil matter,
Yeah.
where money, perhaps damages, are at stake. Your lawyer would get information throughout the entire pending of the case. All the witnesses are deposed in a face-to-face interview that is recorded before even trial begins. All of that disclosure is turned over when money is at stake. For our clients, often sitting at Rikers, none of that happens. We don't get that information until, as you said, the start of trial. And when you think about our system of quote justice, 95% of people plea out. So in a plea situation, you don't see any of it. And you have to advise somebody to take a plea without really knowing what the evidence is. That's right. And that's when liberty is at stake. And so what's wrong with our system? That money becomes more important. That disclosure is far better than the disclosure when liberty or a criminal conviction is at stake.
Wow. Okay.
So looking at the disparity there between, like you said, the difference between money and your liberty when you have free reins to do and live your life, what is this rooted in? Why did New York's criminal discovery process go off the path of the civil?
I think it had to do with sort of back 40 years when all of the laws were actually founded. There was a real, whether it's implicit or explicit, sort of bias as to sort of what DAs would say are protecting witnesses. Right. And it's still rooted. Many of the arguments against, many of the district attorney associations, sort of arguments against this are rooted in this notion of fear, that we're going to place witnesses at fear. And in fact, across the country, where places that are traditionally Republican, Texas, North Carolina, that have done these laws based on justice and fairness, don't see that witness tampering at all. We're right here in Brooklyn, where that district attorney's office does do open file discovery. Right. There are no more witness tampering charges. So it's been all founded in that, and the movement against it is rooted in this fear that is absolutely untrue.
So just walk me through it one more time. I do apologize. What is the process by which the individual district attorneys can choose, it's in all criminal cases, they can just choose to not share their evidence.
The law actually allows them to actually say,
well,
I don't have to give it till trial.
It's one thing if the person that's defending themselves, doesn't have, adequate representation. But, if they have a good lawyer and the lawyer is requesting that information, is it still not made available?
That's right. In a majority of the cases, I'll give you an example. Our client in the Bronx, charged with a bar fight. Police recover a surveillance video that we later find out exonerated him. Even though the DA had that video, even though we made repeated requests and the person was incarcerated at Rikers, repeated requests, they delayed, the DA delayed, until finally we made over and over again, made the applications in front of a judge, and the judge said to the DA, have you even looked at the video? The very next day, the case was dismissed. At that point, our client was in Rikers for 8 months, lost his apartment, lost his job, his family abandoned him. He was forced to move into a family shelter with his girlfriend and his newborn child. That delay happens in many cases. Queen's case, we just litigated this and got an acquittal for our client. That client, Mr. Gills, was, and it was in the New York Times, charged with robbing a Dunkin' Donuts in Rikers Island on high bail for 18 months. We continued to request the evidence in the case. 18 months later, when the DA we started the trial, the DA turned over police reports revealing that another man had been arrested and convicted and was upstate on the same pattern of robberies involving other locations. That person fit the description that was given to the DA by the witnesses, 6 feet, 200 pounds. Our client, Mr. Gills, 5'6", 120 pounds. So clearly he was not. It was not the person. Yeah. And they had witnesses saying he didn't match the description, and they had somebody who was already serving time upstate for some of these pattern robberies. It took our attorneys to go up to visit that person, to upstate, where that man said, basically,
yeah. I did it. Yeah.
Even with that information, case wasn't dismissed. We had to try the case. Obviously, hearing what we said about our client, the jury acquitted. And these are trial cases.
But
remember,
that seems like 95, a colossal waste of time.
Colossal waste of time, colossal injustice.
Yeah.
These two men sat at Rikers all that time. Had somebody just given us the information ahead of time, our job is to review that evidence, to advise our client, to investigate. We can't do that, and our hands are tied, or what we like to say about this law is we're blindfolded. And more importantly, our clients are blindfolded.
So there is a clear prosecutorial sort of stacking of the deck here. They have every advantage when it comes to whether or not they're going to reveal this information to you. I wonder who is the enemy of reform then, because we can change it legislatively. We know Representative Joe Lintal has come forward with a motion that would change the law, but it's dying in the Senate. There's not a New York senator who can say, okay, I agree with you, Representative Lintal, let's change this. Why is the logjam there?
Because I think the district attorneys have sort of used the fear-mongering tactic, unfortunately, to tell a story that simply isn't untrue, and many people buy it.
And we disprove it here in Brooklyn by the fact that with witness tampering, people haven't been offed because they've been named as a witness against or for the prosecution. So I wonder, why do district attorneys have so much discretion in this matter? Like Ken Thompson moved the needle here in Brooklyn, but Cy Vance is sort of notorious in Manhattan for being on the other side of this. So why are individual DAs given so much power in deciding this?
I don't know, but it needs to change. And where I think it's going to change is the growing coalition of people. For 40 years, we've been fighting this.
Okay.
Who's on your squad?
I'll tell you who's on our
the
squad.
coalition, yeah.
The people who were affected. the men who have been sitting at Rikers, who, as they're sitting there, know that they're innocent, want the evidence against them, and either get it or don't. The community members that surround the people who are affected, the family members. So we have now a growing coalition that includes Discovery for Justice, which is a grassroots movement that started in the Bronx, Just Leadership, people who are affected. For years we heard that this is just the lawyers gaming. The defense wants it early because they want an advantage. The district attorneys hold out, they want an advantage. Who is getting lost in the middle of this? The people who are sitting that are affected, the people who take pleas that haven't done it, the people whose cases are pending for weeks, months, years.
Yeah.
Khalif Browder, right? Mr. Serres, Mr. Gills, hundreds of thousands of people who in 40 years that this has affected.
So thank you for
That's
shedding
who
some
moves
light
it.
on it,
That's who
because
moves it.
you never know until you're in that situation, and then you're outraged. What it takes people of goodwill who find out and want to change it before you become a person in
And
handcuffs.
it takes representatives and political will.
That's right,
So-
and we hope we got it. We think we do.
We have a million more questions we didn't even get to, but no, we're completely out of time, but you will come back again to join us and keep
Anytime.
us informed.
Let's keep talking about this.
All right.
Thank you.
Thank you.
Because it's important that we do.